CR 3442, State versus Robin Huerta Hernandez. Can I have parties announced for the record for the state? Defense?
This is Pauline Portillo for Ms. Robin Huerta Hernandez.
And are you Ms. Hernandez?
Yes,
All right, you need to slide over a little bit so that the state will have room. All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes,
Are you the same Robin Huerta Hernandez who was placed on deferred adjudication in 2023 CR 3442 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on August 17, 2023 for a period of 2 years? Is that you?
fine.
All right, state.
Your Honor, we wish to proceed on violation of condition number 4 in Bexar County, Texas. The defendant, Robin Huerta Hernandez, did then and there fail to report to the supervision officer as directed for the months of April, May, June, July, August, and September 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
We waive and abandon the remainders.
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? You need to
Yes,
speak.
yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4? All right, so here's the thing. Let me explain this to you. You've entered a plea of true to violation of condition number 4. Maybe you and your attorney have worked out an agreement with the state. I don't have to follow that agreement. The reason why I don't have to follow that agreement is because you don't have a contract with the state or with your attorney. The contract is with the court, and that contract is your conditions of probation. So by pleading true to violation of condition number 4, I don't have to follow any agreement that has been reached between you and the state. It's just a recommendation, right? So you're looking up, I could revoke you and sentence you to 2 years. I could send you up to 10 years and I can sentence you up to $10,000 fine. Do you understand? Knowing that, do you still wish to plead true to violation of condition number 4? All right, do you want to step back and talk to her some more?
No,
Yes.
Yeah.
Okay, yes, Your Honor.
Sure. All right, we are back on the record and cause number 2023 CR 3442, State versus Robin Hernandez. Can I have parties re-announce, please, for the state?
State.
This is Pauline Portillo for Ms. Robin Huerta Hernandez.
All right, and you're Miss Hernandez? All right, so you had entered a plea of true to violation of condition number 4. The court explained to you what the implications of the plea of true. And I gave you time to confer with your counsel. So do you still wish to plead true to violation of condition number 4?
No.
Do you understand by pleading true to that violation, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. And is there a proposed agreement?
Judge, so there's not really an agreement. Each side's asking for something different. As far as the state and what the state is asking for, we are asking that you deny the motion. However, we're asking for you to alter and amend her condition. We'll continue her on deferred, but alter and amend her conditions for a 1-year extension and order her to go to SafeP due to the struggles that she has had with reporting and failing to submit to her UAs.
All right, defense, what are you requesting?
Judge, we're asking for the extension of the 1 year as well, but instead of SafeP, we're asking for some form of supportive outpatient treatment. Since Ms. Huerta Hernandez was released, she's been doing almost daily NA meetings online. She's been checking in with Ms. Lanier, her pretrial supervision officer, which I I have an email from her in Defendant's Exhibit 1 that she's been in full compliance, no violations on her GPS.
Any
I
objection
have a
to?
chance to review it. I have no objection.
All right, I'll review that.
And the MTR alleges drug use in February, but there have been no positive tests since then. I do intend to call Mr. Mike Hernandez, her fiance, and Miss Hernandez herself to explain the non-reporting. I urge the court, if they're between making a decision between SafeP and what I'm asking for, which is a supportive outpatient program, that they send Miss Huerta Hernandez for drug testing. I do believe she's going to come up negative. And I do believe that I'm going to put on some evidence.
So why hasn't she been reporting?
Judge, it seems like around the time that she stopped reporting in March, she was dealing with some homelessness. And she recently connected with her fiance, and she's now living with him, which was not a circumstance back when she stopped reporting. He's been keeping her on track, helping her to get clean, helping her to look for employment. She has been a victim of abusive relationships in the past, which have caused complete destruction for her. She's lost custody of her children. It's caused drug use. It's led to a diagnosis of bipolar disorder and depression. And so at this point, I think she is in the best position with the support of her fiance, with the support of her fiance's mother, who have been waiting here all day for her. And I think she's just right on track, Your Honor, to not relapse again. She's been doing everything she's supposed to do. She also has some medical disorders that I think are going to cause a problem for her if she had to go back into detention. She has a little eye infection, if the court could take notice of. She has a cut eye that I think she needs to get treated pretty soon, and she has asthma that she said was very difficult for her when she was in SATIF. And Your Honor, I think just the circumstances for her right now are going to be optimal for her to succeed and not relapse. She has no criminal history besides this case. So at this point, I'm asking you, add conditions, weekly UAs, random UAs, zero tolerance, can keep her on GPS. She would like to look for work as a housekeeper at this point to help contribute to the household and get some visits back in. She has ordered supervised visits through Guardian House right now with her 16-year-old. So she really just wants to get her life back together and get back on track.
I'm sorry, what did you say about her and the 16-year-old?
She's supervised visits at Guardian House right now. They cost quite a bit of money though, so she will have to work to try to get those visits in. But that's my understanding from what she tells me is going on with that minor child. She does have older children as well. They're adults. They were here at the last setting, but as far as just the minor, she really has to rebuild that back up because her past relationships have really caused havoc in her life.
Okay.
And have led to these behaviors.
And state.
Judge, I am in agreement. This is her first MTR. She doesn't have any additional criminal history other than this. However, she has had some issues reporting, and I just think she needs a more structured environment to really help her if she's really serious about getting clean. She did complete SATIF, but did struggle in aftercare, and then just kind of falls off the grid, absconded from the jurisdiction of the court. And there haven't been any positives because she hasn't submitted to UA. And so that's why I'm asking for what I'm asking for, Your Honor.
And Judge, I meant to tender Defendant's Exhibit 2 also, which is the verification that she's been attending the NA meeting.
Mm-hmm.
Mission and published to the court.
Yes. Tested today. What are the results going to be?
Negative.
All right, you're going to go do a drug test today. Bashan, she's going to go do a drug test with felony drug court. So if you could have her go, and I'm going to send you some information of who to contact, and they're going to want a photo ID. So if someone can, do you have a photo ID?
I don't, Your Honor.
Oh, they can take a photo, somebody take a picture of her and give it to them. Just send it. All right, we're going to come back with this And she's in custody because she's late, correct? And you're on GPS and you're late. Why were you late?
There was a long line outside, Your Honor, to get in on the courthouse. I was
All right,
here.
So Deputy, what we'll do is we're going to release her so she can go and do her UA. All right?
Judge, will she be brought back here today? So should I just go ahead and
Oh,
wait?
no. Yes, wait. She's going to go straight over there and she's going to come straight back. Her fiance is here. I'm sure he can drive her.
Yeah, sounds good. I'm sorry, but her counsel, I should wait, right?
Yes.
For her to come back. Okay.
And if you speak to Miss Abrams, she'll tell you where you need to go. All right, we're going to go back on the record. And we're back on the record in cause number 2023 CR 3442. Could I have parties announced for the record, please, for the state defense? All right, and this is State of Texas versus Robin Huerta Hernandez. You entered a plea to violation of condition number 4. You entered a plea of true. The court ordered a UA, and you informed the court that you would be negative. I'm sorry?
Want to do that, and I am sorry I didn't tell you. And ask for you to please, and I do want to change. I am changing. I have changed. People have places and things. I do have support now, family support, and nobody knew. I thought it was quick about clean, and I'm sorry for lying. But I do want to change, but I thought it I am, and I want to be in my daughter's life.
All right. All right. Is there anything else from the state or the defense?
Nothing.
All right. You've been missing for many months. That's what your plea of true was. I was informed that you were going to be clean, that you've been doing great work, but you were not clean. The court is going to grant the motion. The court is going to find you guilty. The court will revoke, request the therapeutic community. How much time are you asking for, state? Defense, what are you asking for? All right. The court will sentence you to 3 years in the prison, give you credit for any time served, and the court will retain jurisdiction. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Good luck to you. I will tell you in this court, with regards to drug use, honesty is always the best policy. It's calling 2020 CR 7507. State of Texas versus Desiree Garza.
Is that a question, Your Honor?
Yes. For the state defense parties announced for the record.
Andrew Harris, say it on the.
Michael DeLeon for Ms. Garza.
And are you Ms. Garza? Are you all ready to proceed on the motion?
We are, Judge.
Ms. Garza, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes, ma'am.
Did you understand it and
Yes.
sign it?
Yes, ma'am.
I'm sorry, not sign it, but did you understand it?
Yes, ma'am.
Are you the same Desiree Garza who was placed on deferred adjudication in 2020 CR 7507 for the offense of possession of a controlled substance?
Yes, ma'am.
Penalty group 1, 4 grams to 200 grams on May 4th, 2021 for a period of 6 years. Is that you?
Yes, ma'am.
All right, state.
On or about the 19th day of January 2024 in Bexar County, Texas, the defendant Desiree Garza did then and there illegally use a controlled substance, namely amphetamines, in violation of condition number 2.
How do you plead to that? True or not true?
True.
State waives the remaining violation allegations, Your Honor.
All right, everyone in the box, people in the box, attorneys in the box. Y'all need to move it down to that end because you're talking behind the court reporter and we're on the record. We're back on the record. Did you understand and state, are you waiving all other allegations?
Yes, Your Honor.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There is,
Yes.
Your,
Oh, please go ahead.
there is, Your Honor, to recommendation to alter and amend conditions for M8I supervision, dual diagnosis outpatient program, weekly reporting for 60 days, and monthly UAs for the duration of probation.
I would add to deny the motion, Your Honor.
Okay. Any objection to the court reviewing the court summary?
No objection, Judge.
All right, was she ever sent to safety? So,
According to the court summary, yes, Your Honor. From February 14th of 2023 to August 9th of 2023, with residential aftercare from August 9th to October 8th.
Both of those successfully completed.
all right, so here's the thing. Honestly, don't think you're a good candidate for probation because you've been here before for a motion to revoke. You know yourself better than I know yourself. I'm sorry, you know yourself better than I do. So I'm going to give you a choice. Normally, I can't give people choices. I can revoke you. I'll sentence you to 5 years in the prison. You're looking at 20. I'll sentence you to 5. Or I can continue you. And if I continue you, you're going back to Safe P relapse program. Those are your choices. But you're not going to outpatient treatment. I don't think outpatient treatment is appropriate. So those are your 2 choices. Council, do y'all want to talk about it and come back after the break?
I think we have an answer, Judge.
All right, what is the answer?
A little bit more time. Judge, just to clarify that, Safe P after, what'd you call it?
Relapse.
Relapse, is it 120 to 180 days?
It's probably going to be longer.
Maybe longer, okay.
It's relapse.
Yeah, I don't know if it was 4 months or not.
Okay.
All depends.
So here's your 2 choices. One, you're going to Safe P relapse, or either you're going to prison for 5 years. Which do you prefer?
Up to you.
You know yourself better than I do, better than probation does, better than your attorney does. Either you think you can successfully complete this or you don't. Based upon the fact that you've been here before for not following through, it appears that you do your best work when you're in lockdown situations. For example, when you're at the Safe P, you did well. My understanding, you successfully completed. But then when you get to the real world, you just go back to the same ways of thinking. So that's up to you. So 5 years or either Safe P relapse, which do you prefer?
to the safety.
All right, court will deny the motion, alter and amend conditions to include the Safe P relapse program. And there's to be partial GPS upon release. And that will be for employment and probation classes. And that's until further notice. All right, is there anything else you need from the court to be successful? Yes,
May I also ask for her to be on the mental health supervision?
all right, and MIC. Anything else?
No, Judge.
All right, thank
The judge has heard enough. He says, "You were going to be clean, that you've been doing great work, but you were not clean." He grants the motion, revokes her probation, and sentences her to 3 years in prison with credit for time served. He also retains jurisdiction, meaning she could be released to a therapeutic community if she's accepted. The judge warns her, with regards to drug use, honesty is always the best policy. This case is a powerful reminder that in Judge Boyd's courtroom, promises don't matter if the evidence proves otherwise. Robin had every opportunity to come clean, but she chose to lie, and it cost her. If you found this case as compelling as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.